Welcome everyone. We're going to give our attendees a few more minutes to join here, so sit tight and we'll get rolling here in a few minutes. All right, welcome those that just joined. We're gonna wait a couple of minutes before we get rolling to allow a few more people to sign in. Hi everyone. Looks like we've got somebody joining from Fort Collins. Deb from Woodlake Construction Management. Welcome. If you just want to drop a hi in the chat, please do so. It's good to see everybody here. We'll get rolling here in about a minute or so. Sarah from Lakewood. Hey, Sarah. All right. Well, we will get going here with some introductions, kick this thing off. And if anybody else wants to jump on, they certainly are welcome to do so. So we're recording this webinar today. So the recording will be available here in the next day or so. We'll share that with our group here today. So my name is Dean Isaacs. I'm the founder of Vantage Group. We're a sales and marketing consulting firm. And our esteemed panelists today have asked me to help MC today's lunch and learn, and it is a lunch and learn, so just remember that we're the only ones on camera. So if you guys are eating, that's fine, nobody will see it, so please don't chew too loud into the mic. I'm just kidding. So again, Dean Isaacs here to MC today's event, and as everybody saw on the invitation, we're talking about some state of Colorado human resource and labor regulations that business owners absolutely need to know about. We've got an amazing panel of experts, and we'll go through some introductions here in a minute to make sure everybody knows who we're listening to. But in terms of housekeeping, a couple of other things. If you have any questions at any point during today's webinar, please use the Q&A option at the bottom of your screen. That way we'll get those questions and we'll get them answered as quickly as we can. We'll try and include those in our discussion today. And if we don't get to certain questions, please let us know. And we can follow up the webinar with an email responding to questions that just didn't get answered. So lots to cover, lots of information to share with you this morning. So why don't we do this? We're going to go around the panelists. I'll have each panelist introduce themselves, tell us a little about your experience, what you do. So Wes, please introduce yourself to the group.
Thanks, Dean. Wes Garnett. I'm the CEO, president of W. Garnett and Associates, where we've been in business 16 years. We're a human resource consulting firm specializing in employment compliance. We're currently working across the country, so we provide support services in all 50 states.
Thanks, Wes.
Yes. Hello, my name is Ron Porter. I am the Senior Associate Business Development Consultant with W. Garnett and Associates. I've been with W. Garnett and Associates now for going on years. I specialize in some of the things that Wes had mentioned, I-9 compliance reviews. I also do things like job descriptions, employment offer letters, employee handbooks. I also work with new hire and onboarding orientation, and my background is very extensive. I've worked at several Fortune 500 companies, including United Parcel Service and Federal Express.
And hello, everyone. I am John Bacon. I'm the president and founder of PayThrive, and I've been in the payroll and HCM business for about 16 years. PayThrive is an HCM, PEO, and payroll broker, and we represent over 20 different service providers across the country, predominantly in the Denver West region, but I do have providers coast to coast, and I help people find replacement, HCM, PEO, and payroll providers. And thank you for inviting me to this panel today.
Great. Thanks, John. So we've got a lot of amazing experience on the panel today. So again, I'll encourage you guys, if you have questions, drop them in the Q&A. We'll do our best to respond to those. So we're going to be talking about 3 regulations today. While there are a lot more moving parts to the state of Colorado labor law environment, the 3 that we're going to be talking about are Comps 37, the Healthy Family Workplace Act, and the Equal Pay for Equal Works Act. So those are the 3 we're going to spend some time on. And before we kick it off, I'm actually going to launch a quick poll. And so if you would, each of you, please just respond with how familiar you are with each of those acts. Very familiar, somewhat familiar, or not at all. So I'm going to go ahead and launch the poll right now. Hopefully everybody can see that. And if you would just pick what the response for each of those 3 that are the best and appropriate for you. And what it'll do is it'll allow us to adjust some of our timing, maybe spend some more time on one regulation over another. So that feedback is going to be really helpful for us. So go ahead and start clicking away. It looks like right now, Comps 37, mostly not very well. The Healthy Families, about 50% are pretty familiar. And then the Equal Work Act, Equal Pay, Equal Work Act, about 50–60% are not familiar. Cool. All right, we'll go ahead and let this run. We've got a couple more people that can respond. We've had about 77% of our attendees respond. So if you haven't, I'd appreciate it. Just go ahead and click around and respond to that poll. And then we will wrap that up and move into the content. All right. So I'm going to go ahead and close the poll. And I'll share with you the results. So everybody should be able to see the results. As you can see, for Comps 37, 79% are not very familiar with Comps 37. About an even split, 50% or so are fairly familiar with the Healthy Family Workplace Act, and 43% are not. And then the Equal Pay, a few more people are somewhat familiar. Okay. That would have been our guess, I think, going into this. So we're definitely going to spend some time on the Comps 37, and actually that's where we're going to get going. So I'm going to close that poll, and we'll get rolling. So the first topic, as I said, is this Comps 37. So Wes, you're our lead-off hitter today. So please give us kind of your overview of what Comps 37 is all about, and then we'll get into some questions and dig a little deeper.
Okay, thanks, Dean. Comp 37 is Colorado Overtime and Minimum Pay Standards Order 37. And in fact, this regulation started mid-2020. It was Comps 36, and I think that was in May. And what the order covers, it covers Colorado minimum wage, overtime, meal periods, rest periods, what's considered work, what we can do as employers in terms of deducting from employees' wages. The order requires all of Colorado employees to post this in the workplace. You have to post the order in your workplace, and you can get the poster off of the Colorado.org, I think, coloradogovernment.org website. So you can get the order. This has to be presented to all of the employees. they have to have a copy of this, or it needs to be somewhere visible within the workplace. And again, it covers some of the standard stuff. Instead of going through each one of those, the overtime, the meal rest periods, I just want to highlight a few. Compensable time. Compensable time. For instance, if West Garnett shows up for work and I have to clock in or clock out or change into employers' required clothing, all of that time should be compensable. That should be done prior to me starting work. If, for instance, the employer wants me to run to Kinko's to pick up something, that is compensable time. We should be paying employees to do those types of things. The big part of the order that I want to spend a lot of time around is the exemptions for employees. There are a number of exemptions, and what exemptions are classifications. There are a number of classifications that we as employers can identify our employees around. Examples, I could identify employees as executives, administrative, professional, computer, highly compensated. The regulation specifically hits 3 classifications: the executive classification, the administrative classification, and the professional classification with wage requirements. For any of us to make an employee exempt, there are 2 basic tests that has to be completed. One's called a duty and responsibilities test. The other is called a wage test. And in 2020, the minimum wage for those 3 areas, executive, administrative, and professional, was $35,568. The next 4 years, January 1st, the next 4 years, that base compensation will be increased. For instance, this past January 1st, 2021, that base compensation was raised to $40,500. January 1st of 2022, it will be $45,000. January 1st of 2023, it's going to be $50,000. And January 1st, 2024, it's going to be $55,000. So that means January 1 of 2024, anyone that we've labeled exempt under the executive, administrative, or professional, their base compensation will have to be $55,000 or above. So I would encourage all of the attendees to become familiar with COMS 37. That's it for me, Dean, at this point, unless there are questions.
I do have some questions for you. We'll dig into those. I'm just curious, there's this sort of planned wage increase over the next few years. That's something that business owners should be budgeting for now as well, right? So it's not just responding to a requirement, but in terms of running your business, that's something you need to budget for and plan for. And it sounds like it starts by categorizing your employees so you can budget. A question just came in. Is this just, you mentioned exempt versus non-exempt. Is this for hourly employees or salaried employees?
It's just exempt employees. There are a number of different classifications. One is exempt, one's not exempt. you have 1099s or independent contractors, you have interns. This applies for the classification of exempt. These are people who they're not paid hourly.
Correct. Okay.
In some cases, in all cases, they're paid a salary, which is a fixed amount of money that won't be lessened based upon the quality, quantity, or the number of hours worked, weekly or monthly.
Yeah. So these folks
That
are
wage stays the same.
they're not eligible for overtime, right?
Exactly,
Very good. So we have
correct.
another question, Wes. So the question is, must employers pay employees to get dressed or ready for work? You touched on that briefly. Do you want to give a little more flavor to that?
Yes, if the clothing is required, if it's required clothing, the employee should clock in before they get dressed. Now, if the employee wears the clothing into the establishment, that we don't have to pay them for that.
Gotcha.
But if I carry my clothing to work, I should clock in and then I should get dressed in the company's required uniform.
Gotcha. So that's maybe an example would be a restaurant employee, for example. They may show up at the restaurant already dressed and ready to go. You wouldn't pay them. But if somebody had to put on protective equipment at the job, they would be at the job, getting ready, putting that protective equipment on. That would be paid.
You're exactly correct. They should have clocked in and then put on their gear, their equipment for the shift.
Gotcha. Excellent. All right. Another question for you, Wes or Ron, if you want to respond to this, either of you guys. Can you elaborate on the duty and responsibility definition?
Yes. Again, if we were to take, let's say, the classification of executive exemption, as an executive exempt employee, I have to have decision-making that affects the company. My decision-making can't be routine. I have to supervise at least 2 or more employees. When I say supervise, I'm telling them when to come, where to go, what time to be there, when to leave. The responsibilities of an executive has to impact the business about 75 to 80% of the time. It can't be routine in nature.
Gotcha. Okay, very good. Now, I'm assuming the state provides parameters for these definitions for these different classifications.
You are correct. Yeah. There are data sheets for each one of the exemptions that the attendees could pull down from the federal website and read what they've identified as duties and responsibilities that would fall in the exempt category.
Okay.
I'm in there, Dean, what Wes had said, just echoing, it's very important that employers, really make certain that they're classifying their employees in a proper classification. Because what we've run into, what we've seen is that sometimes employers have a tendency to classify an employee as exempt without taking into account some of those duties and wage tests that they need to take care of and be mindful of. And that can get employers into some trouble misclassifying employees.
Very good. Thanks, Ron. We have another quick question along this line.
Very good point.
Yeah. Does one of the panelists have a link to the website, or where on the state of Colorado website would our attendees go to get these definitions? And we can reply to all the attendees with all of that if we don't have that handy today.
I would think as a follow-up, we can send links to those different pages. Yeah.
All right, very good. So we'll make sure we follow up with the group with that. Very good. Okay, so a couple more questions around Comp 37. So Wes, you mentioned this escalation in pay over the next few years. So what would happen if a business owner didn't comply? So what is the wage claim investigation process? What should business owners understand about that?
Dean, that's an excellent question. And Ron hit on it. If, for instance, we misclassify an employee, let's suppose we made that employee exempt, and whenever the state came in and did their investigation, they determined that the employee did not meet the exemption. Any employee that's in that classification that was labeled, mislabeled, now you're responding to fines and penalties for compensation for overtime that these employees may have generated if they would have been classified correctly initially. Because again, remember, for exempt employees, we don't track the 40-hour work week typically. You know, as if I'm classified exempt, I'm responsible for certain duties and responsibilities. If it takes me 60 hours a week to get those duties and responsibilities completed, you don't see my salary fluctuate based upon the hours that I worked. That's part of the benefit of being exempt.
Thank you.
Add to that too, Dean, what Wes was talking about. It says in the statute that an employee may file a wage complaint with the division, Department of Labor, for any amount up to $7,500. The claimant must provide an explanation that is clear and specific and shows that he or she is entitled to the wages. So there's a process that they must follow in order to file that claim, but they can file the claim, but it has to be clear and it has to be very specific.
Very good. Good. Thank you. Thanks, Ron. So,
You know, just to offer a final perspective on what Wes and Ron were talking about, I guess my takeaway for employers is just like Wes was saying, with the salary exempt threshold rising about roughly $5,000 a year for the next several years, that businesses may have more hourly employees in the coming years, as the employees, if the ones that are compensated close to that threshold level now, they need to keep track of that, because these people, you know, the employer is not required to give them a pay increase. They could just change their status from salary exempt to non-exempt and keep their pay the same. But the bottom line is, some of these people that are right on the edge could go from being exempt from overtime to now you have to track their hours.
got it. Very good. Thanks, John. So we've talked about exempt and non-exempt in this scenario, but what about tipped employees? How does this impact tipped employees? And how do you define the tipped employee? I mean, there's some obviousness to that, but nonetheless.
Well, one of the benefits for employers is the fact that the tip wage right now, this year in 2021, is $9.30. So what that means is, from an hourly standpoint, a tipped employee has to make at least $9.30, hoping that through the course of the week, what they make in tips will take them over and above the $12.31, which is state minimum wage.
Right.
The tip allows us not to pay them the $12.31 per hour. We can pay them less than that, because we know that working and receiving tips, when all of that's added up, it's going to exceed the $12.31. That is the required state of Colorado's minimum wage.
Okay. Good. Very good. Thank you. And one more question in terms of Comp 37. are employees eligible for a tip credit towards the Colorado minimum wage?
Yes, they are. That tip credit is typically, if there wasn't the credit, you would be paying 1231. So the credit, right now, the state says we can pay 930, which is what, a little less than $3 per hour less because of that credit. Because we, on the back end, we're going to assume when we average in the 930 per hour plus the tips that the employee is going to make per hour over the 40-hour work week will exceed the 1231.
And also to a tip,
1231 per hour.
also to a tip credit no greater than 43.02 per hour may be used to offset your direct wages of cash of the tipped employee. So it's just saying that, you know, as long as it doesn't go beyond the threshold, they can use that as direct wages.
Okay. All right. So that's an important number to remember. Very good. Okay. And finally, we talked about the types of positions and requirements that this does apply to, but what are the exemptions, you know, for Comp 37? What are the exceptions?
It in the code of, excuse me?
Oh, no, go ahead.
In the Code of Colorado regulations, it's a number of pages. So I would encourage people, if they have the time, to read that, because all of the regulations start there. And it's a lot of information. It's a lot of information to be responsible for and to know when it comes to Comp 37. A lot of rules that apply to Comp 37, again, are found in the Colorado Code of Regulations.
Okay. So if you were going to share with the attendees today, what are the couple of really big takeaways that they should remember? So grab your pens, attendees, write these down. These are the takeaways for Comp 37.
Dean, the number one would be time worked. There are a lot of areas that employers now are not compensating employees. So they stand the chance on having those areas audited if an employee were to go to an attorney or to a third party. So become familiar with what some of those are. And again, putting on and removing required work clothing, that's compensable time. If the employee asks me to come into work, I'm at work, but they haven't assigned me any duties and responsibilities. While I'm waiting, that's compensable time. So just become familiar with those regulations. And again, they're all a part, not all of them, a lot of them are part of the poster that makes up Comps 37.
Okay.
You know, I would offer up the tracking, the fact that employers will have more hourly people working for them in the near future for those folks making, you know, previously salary exempt earnings that were kind of near that threshold, which is, you know, like 35, a little above 35,000 now. It's going to rise each year, and on the state level, or you know, about 5,000 a year for the next like 4 years or so. That a time system, some way to track time, it's not required, but you kind of put yourself in the shoes of the agent from the agency. When they come in, what sends a message that you take this seriously, that you take, you know, tracking an employee's time worked seriously? a spreadsheet versus some kind of a time system where the records are locked after the pay period is done. Just things to think about. And again, it is a scale issue. Small employers with a couple of people, maybe not a burning issue, but the larger an employer is, something to think about. And it also touches on things we'll talk about later, potentially as far as leave.
Yeah. Okay. Do you have any recommendations of tools or platforms that are easy to use for employers to track time?
It's a great question. What I would tell folks is the simplest thing to do is to start with your payroll vendor, see what they offer in terms of a time tracking system, with the assumption that that system they would recommend would integrate, would play nice with your payroll system, would receive data more easily than maybe a third-party system, maybe. So if your vendor offers that, that's great. That's a great start. Some more advanced platforms, like an HCM platform, a single database kind of payroll HR platform, the time system might be just a matter of flipping a switch on the provider's side, and now it's on the same platform. So it could be very easy that way. But it's not. You can also look at third-party systems. There are so many out there, some that are industry specific, that are really good for construction. Some are better for, the restaurant industry. And also, restaurants, for example, you've got a POS, a point of sale system, and that it can function as a time system in terms of people having to log in and out at the beginning of their shift and end of their shift. So,
okay, very good. Well, great. Well, it sounds like there's a variety of options. And I would say to the attendees, if you have questions and you're not sure, reach out to John. I'm sure you'll be happy to respond to questions if any of the attendees have them. So thank you for that. Okay, so we're going to move on to the next regulation. And Ron, you're up to discuss that. So what we're going to be talking about now is the Healthy Families and Workplaces Act. So Ron, give us an overview, if you would, please.
Okay, thank you, John. Excuse me, thank you, Dean. And just going to share with you a little information regarding Healthy Families and Workplace Act. Under Colorado law, Healthy Families and Workplace Act became effective January 1, 2021, which means that all employers with 16 or more employees must provide sick paid hours for full-time and part-time employees to accrue and use when available. And starting next year, January 1, 2022, all employers must follow these guidelines under Healthy Families and Workplace Act. The formula that's applied is that for every 30 hours worked, employees will earn 1 hour of paid sick time. And this time will cap off at 48 hours per year, meaning that employers, once they accumulate to 48 hours, the system will shut off and they won't accrue any more time during that year. The law is also in connection with the federal law, Families First Corona Response Act, which mandates that employers with 500 or more employees must provide 2 weeks paid sick leave for their employees. This law also prohibits employers from retaliating against employees who request and or take paid sick leave, informing other employees about their rights under the statute, filing a complaint against an employer, or assisting in an investigation about paid sick leave. So employees have that right that if they feel as though that something is wrong, and they want to share this information with other employees, employers cannot retaliate against them for doing so. The employer must notify employees in writing of their rights to take paid sick leave in the amounts and for the purposes in the law. In addition, the employer must post the approved poster, which is issued by the Colorado Division of Labor Standards and Statistics. And that's just some of the information regarding Healthy Families and Workplace Act.
Interesting. Okay, thanks. So we've got 2 stages to this thing rolling out by the sounds of it. First is this year for 16 or more employees, and then after that, everybody. So if you have 1 employee, you fall under this particular act. Um, Very good. So we have a quick question that came in. Can we get the accrual rate one more time, please? Can you share that again for us, Ron?
So the accrual rate is that for every 30 hours worked by the employer will accrue 1 hour of paid sick time. And then again, it caps out at 48 hours per year.
Thank you. Very good. Good. So that's in addition to any kind of PTO plan or anything, any other sort of like vacation plan. That this is just for sick time.
Yes,
And Dean, could I also add to what Ron has said? For this law specifically, I would not be looking at whether a person is a full-time or part-time person. I would be looking at the hours that they're working. Because again, a part-time person, soon as they hit 30 hours, they have now accrued 1 hour of paid sick time.
Oh, okay. Okay.
So and a lot of the regulations, part-time employees don't qualify. But this law specifically addresses that part-time employees will qualify for paid time off if they're hitting these 30-hour benchmarks.
Right. So that's a clear gotcha for employees if you don't understand that. So that's really important, Wes. We do have a few additional questions that came in. Since this is an additional expense for employers, is there some assistance for them? So I'm assuming some kind of state supplementation or assistance. Are you guys aware of any kind of assistance?
Dean, I would think that some of this might apply under PPP.
Mhm.
But I don't think I haven't read any waivers that the state of Colorado have provided.
Yeah, in terms of contributing to the earnings that go into that number that you report on the PPP application, that's a good point.
Okay.
Excuse me.
Another question, does this start over January 1 each year? So I'm assuming the accruals is what we're referring to here.
Yes, and the other gentleman can chime in as well, our other panelists, but it accrues up to 48 hours, and then it caps off there. And I believe there is, if you have a little bit left over, you may be able to carry some over, but some other gentlemen can chime in on that as well.
That does make me think of something that, because I was going over the law again recently, and so the Healthy Families and Workplaces Act, it does allow employers to provide it as paid leave as PTO earnings, so they can classify it as PTO. But my thought is that employers should not be lulled into complacency, and really, I would not lump it in. I would differentiate it. I would call it something else just to keep it clear, just to be able to track it and to have those buckets not mixed, so that you're kind of, in terms of researching something or potentially having to prove something to an agency, the leave will be separate and kept clean. But regardless of what you call it, you got to follow these guidelines. Yeah. And I think as I recall, in terms of salary workers, it makes the assumption, that they're working 40 hours a week and accruing it at that level, salary exempt. Am I correct, guys?
Sounds like it.
Yes.
Yep. Okay.
Yes. Okay.
So we're not. Is there a clear definition of any rollover that's available in those hours? Is that clear in the statute? Do we know?
Yeah, and I think you can roll over, and again, we will check. I think an employee can roll over up to 48 hours a year.
Yeah.
Oh, okay.
That's my understanding.
They can roll over up to 48 hours.
The unused, the
unused
leave they're
portion,
carrying forward. Yeah.
So an employee uses 24 of the 48 hours in 1 year. those 24 hours that wasn't used the previous year can be rolled over to the next year. So it would be 48 hours plus the 24 that wasn't used the
Gotcha.
previous year.
Thanks. That we had a few questions about rollover, so that's good to clarify that. Thanks, guys. So this is obviously a very popular topic because we've got more questions rolling in, and we'll just keep going through them as long as time allows. So if an employee, let's see, if an employee needs to be out for COVID reasons under FFCRA, what happens to their sick time under the Colorado law? Is that considered regular sick time, or is there some special treatment for COVID specifically?
Well, for COVID, as far as federal law for the Families First Coronavirus Response Act, that goes into play for employers who have 500 or more employees.
So we would, from what you just said, I would assume that those smaller employers, if you're out sick, you're out sick, whether it's for COVID or another reason. It's all part of the same bucket of time.
Right, and part of the Healthy Families and Workplace Act has been, if you will, designed to kind of mirror the federal law, which means that for those individuals who have 16 or more employees that don't fall into that 500, I think that encapsulates and captures them.
Okay, thanks.
But in 2022, guys, does it go all the way down to one employee at that point? So
Yes.
Next year, everybody falls under the
Yep.
the Healthy Families and Workplaces Act requirement.
Yep. Okay, very good. All right,
Indeed, just to add to what Ron has said, there's a process that the employee has to follow to qualify for this. There's a process that the employee will have to follow to qualify for paid leave of absence.
Okay. Very good. All right, just a couple more on this particular topic. Can you provide the full 48 hours of sick time up front at the beginning of the year, or must you do it in that accrual rollout throughout the year as an employer?
I think that you can give them this at the beginning of the year, just so, and I think as John indicated, just so you're differentiating what this leave is. If you're giving me my time up front and I don't need to accrue it, I don't think we have any exposure from the state of Colorado. What they want to make sure of, employees who are accruing this time through the course of the year, they have an opportunity to get the time.
Yeah, okay. So there are some consequences to that, which ties into the last question that we had. If they leave, is that time, should that time be paid to them if they haven't used it? Or on the other side of the coin, if you give them all that time up front and they leave, how is that handled?
Great question. The way the act reads here for the healthy families, you don't have to pay them when they leave. You don't have to pay them when they leave. So that's one of the reasons why there should be differentiation.
Mm-hmm.
Some of our clients roll it into PTO, and depending on how they're accruing PTO, that could become now paid time when the employee leaves. So I think it's to our advantage to differentiate how we're tracking this healthy family 48-hour time.
Yeah.
And to echo Wes's point, where they could potentially call it all PTO and lump the leave in together, and then maybe keep a separate spreadsheet. It's probably not a good idea in terms of having it look legitimate, in terms of showing an agent from Department of Labor and Employment a report showing leave taken. Sure would be nice to have that leave be very clearly under the Healthy Families and Workplaces Act.
Yeah. So have a system, document clearly. Sounds like we need to make sure we separate those hours for all of those reasons above. Good. Well, to wrap up this particular regulation, Ron, I think we've covered a lot of the questions. So maybe share with the attendees one or two, what you believe one or two of the biggest key takeaways are for the Healthy Families Act.
I believe that one takeaway that I think is very important is that you have quite a few employers out there that might think that, well, I only have 10 employees, so I really don't have to worry about that until next year. I think being proactive and as a best practice, they should start the process of getting some type of retention records in place that can track that. So that way, when it comes to next year, they're already up and running and ready to go as far as keeping a tracking system in place to track those hours. So that's one thing that definitely I think that they should be doing. Also, too, I think that employers should definitely, if they're not sure about this, they should reach out to someone, that can help them assist that to put together some type of tracking system that will assist them where it's running proficiently, where it's also differentiating between part-time and full-time employees. You don't want to get hung up on that. You should just make sure you're tracking both of those part-time and full-time employees.
Right. Yeah, there's a lot of moving parts to this regulation. And again, I'll offer to the attendees, if you guys have questions, Ron and Wes and John's contact info is obviously in their background there. Write it down. Don't hesitate to reach out to these guys. They're available to answer any of these kinds of questions. Okay, so that is Healthy Families and Workplace Act. If we have nothing else to add, no more questions, we'll move on to our third topic, which is equal pay for equal work. And Ron, go ahead and give us the overview of that, if you would, please.
Okay. The Equal Pay for Equal Work Act was created to broaden and address pay inequities in the Colorado workplace. This new law protects against discrimination because of sex, that's including gender identity, and is in connection with Title VII, which provides protections against discrimination in several categories. And it also enhances the Equal Pay Act of 1963, which prohibits employers from paying unequal wages to men and women in the same workplace who perform substantially similar work. The provision of Equal Pay for Equal Work Act consists of employers may not pay another employers may not pay another of one sex less than an employee of another sex for substantial similar work. And the measurements involved in that is like skills, efforts, and responsibility. However, an employer can avoid legal liability under this new law if it demonstrates that the entire difference in compensation is based on at least one of the following factors: a seniority system, a merit system, a system that measures earnings by quantity or quality of production, the geographic location where the work is performed, education, training, or experience to the extent that they are reasonably related to the work in question, travel, if a regular and necessary condition of the work performed. And there are two provisions that I do want to just emphasize and share with you as a high level point. Pay history. Employers cannot seek the wage history of a prospective employee, rely on the wage history of a prospective employee to determine the wage rate, discriminate or to retaliate against a prospective employee for failing to disclose wage history. Pay transparency. This law prohibits employers from preventing their employees from discussing their own compensation information with others, requiring employees to sign a waiver that prohibits his or her ability to do the same. The employer must make reasonable efforts to ensure that the notice of the promotion opportunity is provided for all employees on the same day and before the position is filled. And the notice must include information about how to apply for the position. Also, too, employers are not required to provide notice of promotion if one of the following exemptions. So it's just saying that there are some exemptions that employers can rely on. They don't have to provide this information. The employer needs to keep an opening confidential, employer needs to keep the opening confidential because the position is still held by an incumbent employee and the employer has not had the opportunity to let the employee know that they're being separated. The employer intends to promote a recently hired employer pursuant to the express agreement entered into at the time of hire that the employer would automatically consider the employee for promotion for this position within 1 year or hired based solely on the employee's performance and employer needs. And also to the employer, if the employer is going to be hiring this position, it's going to be 6 months or less. So this is just some of the information that I want to share with you regarding the Equal Pay for Equal Work Act.
That's interesting. You know, some of the things you mentioned there, maybe it's sort of like what we believe the best practices were versus what the regulations require. And just an example that came to mind was the sharing of prior income, prior salaries. And so I know I've had lots of clients over the years, especially when they hired salespeople, they want to know the salesperson has been able to generate X amount of income to themselves, and that they believe that equates to their ability to sell. So if you are hiring a salesperson, they would often ask, hey, I need to see your old W-2s to make sure you actually did make this amount of commission. So we know that you have some level of expertise coming into our sales role. Sounds like now they can't do that.
No, and you know, the other thing too is that the employees do have recourse, meaning that individuals who believe that their employer has violated the transparency provision of the Equal Pay for Equal Work Act may either file a complaint with the Department of Labor or proceed directly to court. So they do have some recourse if they feel as though that this information, this transparency has been violated.
Yeah. I think that this is an interesting one, as I said, because I think there are some sort of like general best practices that employers would use. And we need to make sure those are aligned with the current regulations, because it sounds like in many cases, just because that's the way we did it doesn't mean that it's legal anymore. So attendees, make sure that you're sort of like the way you did it aligns with the current rules. The last thing you want to do is get stuck in a situation because that's just the way we did it. Okay. So Ron, or to any of the panelists, so what are the new notice requirements businesses must follow around this act?
Dean, one of the things I would want to inform the attendees of, because of the fact that you have to post this internally if you're going external with the job, is to, when you do the job description, which is a requirement, put somewhere in the job descriptions, have a minimum set of requirements. So if an internal employee wants to apply for this, they're meeting a certain minimum threshold to be considered a candidate.
Right.
If you've established that and someone doesn't meet that minimum requirement, you don't have to include them in the process.
That makes sense. Okay, so that's a good rule of thumb for any position, is to make sure you post minimum requirements, but in this particular case, it protects you as well. Okay.
Yes.
So we have about 7 minutes left. So let's maybe touch on one or two more questions for this act. And again, attendees, if you want to throw a question in there, please do so. Oh, Pamela, does Equal Pay for Equal Work Act apply to all sizes of employers?
Yes, it does.
Okay, very good. That was an easy one. Yes, is the answer to that, Pamela.
I wanted to offer this too, that because I feel like I've been talking a lot about record keeping with my comments today, and I feel this one is no exception. Absolutely not. In terms of equal pay for equal work, employers need to keep detailed payroll records. You know, they need to keep track of the current role, the history of promotion, pay history with employees, but they also, some employers benefit greatly from word of mouth promotion for filling positions internally, which is, you know, beautiful if you can have that. It makes life easier, but they might consider, because of this law, formalizing their recruiting process. You know, maybe considering, if they've not used it before, using an applicant tracking system if they're trying to reach externally. I mean, if they're only going to promote from within, maybe, and this law would probably be fine with that, maybe that's not an issue. But if they're looking for external candidates, and this law is about posting that information at the same time, making sure that internal employees and external candidates get that information at the same time, an applicant tracking system of some kind, allowing you to do that easily and giving you a database of who applied, so you've got a record of candidates, data you own. That's crucial.
Yeah, no, that makes sense. Again, there's that requirement upon the employer to stay organized, document, right? It goes on and on. All right, so Ron, I'm going to give you one, or any of the panelists, what is the one key takeaway for this act that the attendees should keep in mind?
Well, I'll just briefly say that one of the key takeaways that I think is that, you know, the process is not the way it used to be. It's different now, meaning that, you know, employers must do their due diligence, making sure that if they are providing similar work to employees, that they need to make sure that they're doing their part in taking the necessary steps and ensuring that they're addressing any employees that might be, you know, working for them internally that may have the qualifications and skills, abilities to apply for that position.
Yep, very good. Thanks, Ron. Okay, so we're gonna wrap.
Dean, and one other takeaway. Dean, can I just say one other takeaway? And that's going to make sure what used to be a no-no for us that's been in the workplace for a long time was the sharing of comps. Here in Colorado in 2021, it's not a no-no anymore. When you read the regulations, they're almost encouraging employees to tell one another what you're making. So that is a big change that we're going to have to become used to.
Yeah, that's I can't tell you how many business owners I work with that, you know, they just beat that into their employees. Don't share your pay with other employees.
Yeah.
Well, it's a big change, right? Again, just because you did. All right, so let's wrap this thing up. We appreciate all the attendees being here today. We're planning on doing more of these lunch and learn webinars in the coming months, and we'd love to have your input. If you have any topics, HR, payroll, labor requirements, throw them in the chat, throw them in the Q&A. We'll definitely add those to our list of potential topics for the future. One of the things we were thinking about, and this may seem like a basic topic, but it's a big gotcha, is the I-9 and how that can really get employers in trouble when employees don't complete the I-9 correctly. So Wes, maybe give us an example of why we should care about making sure the I-9 is completed right.
Oh boy.
Dayton, this is a great question. And let me share a quick story. I'm currently working with a new client. There are 7 employees. The company is made up of 7 employees. I did this past week the I-9 audit. The audit in fines and penalties is exceeding $90,000 in fines and penalties for those 7 employees.
$90,000.
So please, 90, yeah. And Dean, I'm using some figures that are a couple of years old. For instance, if the date is incorrect in the I-9, I'm using a figure of $2,156. That price has gone up. So it's more expensive now if that violation is a part of that I-9. So that 90,000 is a conservative figure for this company.
Wow. And that's a small business, right? I mean, that could be a major issue. And that's a gateway to being audited, I'm sure, for a whole bunch of other things. Wow. So it looks like I have a quick question. We may have a minute to respond. Also, with all remote workers, the I-9 is even more precarious. How do we get to verify if an employee is out of state? All right, so I'm going to put a pause on that one. Show up to our next webinar, guys. We don't have time to cover it. We'll cover all of that stuff. So a little teaser for you. So thanks for everybody for joining. We will share a link to this recording. We will share links to all of the regulations we talked about today and all the resources on the State of Colorado website, because that can be a mess to find. Again, please reach out to our panelists. Ask questions. They're available. They're willing to give some time to you guys to make sure we answer these questions as well. So really appreciate everybody attending, and we'll see you on the next one.
Thanks everyone.
Bye-bye.
Thank you.